meeting of the Joint Subcommittee to Study Comprehensive Campaign Finance Reform is called to order. Good afternoon. I am Rashana Senior from the House Clerk's Office, and I will be your clerk today. I'll begin by calling the roll. Please indicate your presence when I call your name. Delegate Simon,
Here.
Delegate Bulova,
Here.
Delegate Bagby,
Present.
Delegate Scott, Delegate Byron,
Here.
Delegate O'Quinn,
Here.
Senator Deeds,
Here.
Senator Norman, Senator Favola,
Here.
Senator Surabel,
Here.
Allison Blow, Ann Hess, Natalie Robinson.
Here.
A quorum is present. The first order of business is the election of a chair. Nominations are now in order.
Madam Chair, I would like to place in a nomination Delegate Marcus Simon.
Is there a second? It has been moved and seconded that the Joint Subcommittee to Study Comprehensive Campaign Finance Reform elect Delegate Simon as chair. Are there any other further nominations? Hearing none, all those in favor of electing Delegate Simon as chair, please say aye. Opposed, no. The motion passes. Congratulations, Mr. Chair. I'll turn the gavel to you to
Thank you.
proceed with nominations for vice chair.
Thank you, Rashawn. So I guess our next order of business is election of a vice chair. Are there any nominations?
Mr. Chairman,
Delegate, Senator Bulova.
I
Senator
nominate
Favola.
Senator Deeds. It's okay.
It's been moved and seconded that Senator Deeds be the elected vice chair. Are there any other nominations? Seeing and hearing none, as many as favor that motion will say aye.
Aye.
Those opposed? Congratulations, Senator Deeds, I think. All right, thank you, members of the commission. We've got an agenda before us. We've gotten through the first two items, which are the call to order and the election of a chair and vice chair. Next on our agenda is a presentation, but before we get to that, if we could just take a moment to go around and have everybody briefly introduce themselves. Was it? Oh, I'm sorry. Before we get to that, we have a statement that we need to have the clerk read pursuant to our, to describe how we're going to meet and the interaction between the virtual and the in-person participation. So, Madam Clerk.
Okay. In accordance with Chapter 1 of 2021 Special Session 2, the chair has determined that the policy of this joint subcommittee is that meetings will be conducted by electronic communication means without a quorum being physically assembled in one location, subject to the following. 1, the meeting is being held to receive presentations, updates, public comment, or conduct other forms of information gathering, including asking questions. 2, taking notes or making formal recommendations shall only occur when a quorum of this body is assembled in one location. In no case shall a member participating by electronic communication means vote. 3, all members of this joint subcommittee will be provided a means to enable them to participate by electronic communication means. 4, when a meeting is conducted by electronic communication means, any interruption in the electronic broadcast of the meeting shall result in the suspension of action at the meeting until repairs are made and public access is restored. And 5, meetings of this joint subcommittee conducted by electronic communication means will cease when the related authority under Chapter 1 of 2021 Special Session 2 expires.
Thank you, Madam Clerk. And I think what that all means is that we're going to take advantage of the language that was in the recently passed budget to allow for virtual meetings when we're not voting or doing anything substantive, just to receive information. So thank you for that. All right, so before we begin with NCSL, if we can go around the dais, and particularly interested in hearing from our, and on Zoom, to have everybody briefly introduce themselves so that members of the public know who is on the commission and how they got to be here. So if we want to start with Delegate Bagby.
Delegate Bagby, representing the 74th House District, Eastern Henrico, and parts of a little part of Richmond. Also chair of the Virginia Legislative Black Caucus.
Thank you.
Thank you, Mr. Chair. David Bulova, representing the 37th District in the House, which is the city of Fairfax and parts of Fairfax County. And I just want to say thank you, everybody, for engaging in what I think is going to be a very important discussion.
Senator Deeds?
My name is Creed Deeds. I represent the 25th District in the State Senate. I live in Bath County, and I chair the Privileges and Elections Committee in the Senate.
I'm Tommy Normant, and as a result of redistricting, I represent the 3rd Senatorial District, which runs from the North Carolina border to the Richmond city limits, and have had the opportunity to make a lot of new friends on that. And other than that, I'm just a pissant in the Senate.
Good afternoon. I'm State Senator Barbara Favola. I represent the 31st Senate District, which is large portions of Arlington, parts of Fairfax, and parts of Loudoun County. And I'm very much looking forward to the work that this committee is going to do. So thank you for convening us, Mr. Chairman.
My name is Scott Suravel. I represent the 36th Senate District, which for the time being is Fairfax, Prince William, and Stafford County. I defend our border from the hordes in Maryland, and I'm happy to be here to talk about campaign finance reform.
I'm Ann.
And is your microphone on? I just want to make sure everybody can hear you.
Okay. I'm so used to everybody taking care of me already. I'm Ann Hess. I'm a citizen member of this committee, and it's an honor to be here to discuss campaign finance reform, and I think it's a very important topic. I'm a member of the League of Women Voters, as well as a number of other organizations that are also interested in this matter. So thank you so much.
Thank you. And I'm going to switch over to Zoom now. The first person I see is Delegate O'Quinn. So if you want to go ahead and go first.
Thank you, Mr. Chairman. Israel O'Quinn. I represent the 5th District in the Virginia House of Delegates. That's all of Grayson County, parts of Smith and Washington County, and the cities of Bristol and Galax.
And Delegate Byron, do you want to go ahead and introduce yourself?
Yes, thank you, Mr. Chairman. My name is Kathy Byron. I represent the 22nd House District, which is parts of the city of Lynchburg, parts of the counties of Campbell, Bedford, and Franklin.
Great, thank you. And I think Natalie Robinson, one of our citizen members, is on the line. Natalie, is that you?
Yes, hi, I'm Natalie Robinson. I'm the 2nd citizen member. I was appointed by the speaker, and I'm very happy to be participating in this initiative.
Thank you. And then if we can quickly get the staff here, we've got we've already met our clerk, Washana Senior. She led off the meeting, but if we could tell us who else we've got up front.
Mr. Chair, Cheryl Wilson with the House Clerk's Office.
Thank you.
And Mr. Chair, Brooks Braun with the Division of Legislative Services.
And so, Brooks, you've been detailed to this this committee. Is that right?
Yes, I have.
All right, very good. All right. With that, I think we all know who we are and why we're here. And I think what we're going to try and do today with the first meeting is what I've asked staff to do is prepare, have a presentation, which we'll get in a second, from the National Conference of State Legislatures. I think what we want to do today is to get an idea of where we are in Virginia compared to the rest of the country. In what sense is our campaign finance system an outlier? Where are we lacking compared to some other states? And I know that we also will get some public comment. And I want to hear from members of the public about where they think we should be focusing our efforts in the 4 meetings that by statute we are allowed to meet. One of the challenges we've got here is that the legislation that creates the commission says we need to do 4 meetings, and we're anxious to do that and achieve something and accomplish something at each and every one of those meetings. But today what I'd like to do is get a sense of where we have room to improve, maybe identify some relatively obvious, I won't say easy because nothing's easy, but some relatively obvious places to improve, and where there's some concrete ideas on how we can move the ball forward on that, and then determine a work plan before we leave that we can give to ourselves and to staff so that they have an idea of what to do for the next couple of months while we get the next 3 meetings planned. So with that, we have with us a guest speaker from the National Conference of State Legislators. Brooks, do you want to introduce our NCSL speaker, or are you the best person to do that? Or do they want to have them introduce themselves?
Yeah, let's have Christy introduce herself, Mr. Chairman.
All right. Christy.
All right. Well, thank you, everyone, for having me. I hope you can see my screen, my presentation.
We can see it. It's up.
Great.
For all of us. To see.
Fantastic. Fantastic. Well, thank you, Mr. Chair and members of the committee. I am Christy Zamarripa, a policy associate in the Elections and Redistricting Program at the National Conference of State Legislatures. I appreciate this opportunity to present before you today on campaign finance, a state overview. Before I begin, I want to be sure that you know that NCSL is the nation's bipartisan organization serving the needs of legislators and legislative staff throughout the states and territories. While our structure is bipartisan, our work is nonpartisan. NCSL serves over 7,000 legislators and 25,000 staff. You can see on this slide what we do. Our bread and butter is responding to research requests from legislators and legislative staff. We do so in a confidential manner. So if any of you would like to contact me after today's meeting about campaign finance or any other topic, please feel free. We welcome questions. If I am not the person with the knowledge on your question, I will be able to find a person who does have that. One more note, NCSL does not offer advice on policy matters that come before state legislatures. Instead, we provide a 50-state perspective on key topics. Today, I will do an overview on many trends and major issues within the broad category of campaign finance, and lastly, touch on a few key court decisions. This year, 45 states have introduced campaign finance related legislation. Close to 500 bills have been introduced so far. Over the last 5 years, there have been over 3,100 legislative bills introduced throughout the states, with 360 enactments. This percentage of enactments to introductions is on par with other areas of election-related legislation. I have categorized the action into major and minor categories. In each, there are 4 subcategories. Within the major trends, disclosure and reporting requirements are the most common area for legislation, followed by campaign contribution limitations. A quieter topic is public finance, and the 4th category is legislation addressing the enforcement and penalties for violations. I will talk about each of these major topics in some detail later, but I will start with minor ones. On this slide, I will touch briefly on what I'm calling mini trends. The first is the allowances and restrictions on the use of campaign funds by candidates. Most states follow federal laws in prohibiting the use of campaign funds for personal use, although some states are expanding permissible expenditures, such as the use of campaign funds for child care. Often, the campaign finance regulation entities in states act on a case-by-case basis on what is personal use or what is a permissible expenditure. Since the Federal Election Commission allowed a candidate running for New York's 2nd District to use funds for her bid for Congress, I've noticed that states have been introducing legislation to allow candidates to use funds to pay for childcare during campaigning. At this point, 8 states have enacted legislation permitting campaign funds to be used for childcare. Minnesota was the first state to pass legislation, doing so in 2018. Since 2018, there have been 50 bills introduced in 15 states. The next mini trend is limits on foreign campaign contributions. The Federal Election Campaign Act prohibits foreign nationals from making contributions in U.S. federal elections. However, some states have introduced legislation to limit foreign money. First, they have increased transparency in money in elections consistent with the First Amendment to the U.S. Constitution. Second, states have prohibited certain committees from knowingly accepting contributions from any natural person who is not a citizen of the United States, a foreign government, or any foreign corporation that does not have the authority to transact business in the state. And third, make it unlawful for any foreign national directly or through a third person to make a distribution or disbursement for electioneering communications, a contribution, or expenditure. The Supreme Court has held that corporations are indeed permitted to spend corporate funds on campaign-related ads or other expenditures. Washington State has enacted legislation that revises provisions relating to the level of corporate national ownership of corporations that participate in state elections. Now, in the last 5 years, 16 states.
This is Delegate Simon here. Do you mind if we interrupt you every now and then for questions? Is that okay as we go along, or would you rather wait and take them at the end?
Mr. Chair, I'm perfectly happy to take any questions if things pop up or after.
All right, well, I'm going to interrupt you then with a question. I'll take the chair's prerogative for a second. So on the limits to foreign money, Washington State essentially said even though corporations have to be allowed to give money, can you go a little bit more detail on what they've said? If the corporation is mostly foreign owned, then they can't. Tell me a little bit more about what Washington State did. Not a whole lot more, but just a little.
I believe in Washington that there are limits as to any corporation that has ownership outside the U.S. They are prohibited from making any kind of contributions. And they specifically state that they must be able to do business in the state or registered in the state in order for them to be able to contribute to a candidate.
Thank you.
Or other entities.
Thank you. Go ahead. I'm sorry.
No, that's quite all right. So the next mini trend that I will talk about third is the rise of digital ads on social media platforms. Political advertising has long run in print and radio and television to now digital advertising on social media platforms, websites, search engines, and more is common. The same regulations that worked in traditional media don't work as well because online ads are tiny. So it's not possible to put the full disclosures as it is required on radio or a TV spot or at the bottom of the mailer or print ad. Political candidates and other users have spent 3 times more money on digital political ads in the 2020 election cycle than in the 2016 cycle, around $1.3 billion. This is a new topic for legislation. Since 2018, 11 states have introduced 24 bills related to digital and online ads and platforms. California, Maryland, New York, Washington, and Virginia have enacted bills. All the states except Washington, where the campaign or the entity that is running the campaign is responsible for disclosure, except Washington. And in Washington, they added digital political advertising to the state's disclosure rules and requires that ad sellers provide a publicly available record of campaign advertising information. So the last minor trend that I wanted to mention is associated with the timing of contributions. And 29 states have placed restrictions on the giving and receiving of campaign contributions during legislative sessions as a way to dampen corruption or the appearance of corruption. In some states, the ban applies only to contributions by lobbyists or by political committees. Other states have a general ban on all contributions during session. Now I will go a little bit more deeply on the 4 major campaign finance issues, starting with disclosure. Now, disclosure laws vary by state, but the general framework is quite uniform. Most campaign finance disclosure laws require candidates, political parties, and groups that primarily work to elect or defeat candidates, or in other words, anyone who receives contributions for their political work, to register in the state and to file periodic reports listing information about their donors, contributions, and expenditures. Disclosure and reporting requirements account for a third of all campaign finance legislation over the last 6 years. Now, these laws may address who needs to disclose, potential candidates, political parties, political action committees that receive contributions. The National Institute on Money in State Politics projected that contributions near close to $1.9 billion in the 2020 cycle for state level candidates. This would be up from nearly $1.6 billion in the 2016 cycle. All 50 states have some form of disclosure and reporting requirements of contributions. Now, for expenditures, 48 states require the disclosure or reporting of candidate expenditures. Now, reporting schedules may vary. Most states require disclosure on contribution expenditures either annually, quarterly, monthly, right before an election, or soon after an election. Some states also require a candidate to disclose receipts of large contributions within 24 hours. Now I'm going to briefly discuss disclosure and reporting requirements for independent expenditures. Now, an independent expenditure is an expenditure for a communication that expressly advocates the election or defeat of a specific candidate and is not made in coordination with the candidate's committee, or the candidate's political party. Groups that run independent expenditure ads for or against candidates must report these expenditures and often must report donations if specifically earmarked or directed to support the independent expenditures. With no contribution limits on independent expenditures, some states have established reporting and disclosure requirements, including donor disclosures if they meet a monetary threshold. Generally, state campaign finance laws regulate the individuals or groups making expenditures based on the type of expenditures and not the type of group. So the type of expenditure usually triggers the disclosure rules, if any. I'm going to talk about 3 different types of communications and disclosure requirements. For express advocacy, now, those are communications that include the for or against statements. 3 states require groups making independent expenditures to register as PACs, or political action committees, and follow all the rules applicable to political committees, including donor disclosure. Another 21 states require general donor disclosure above a specified monetary threshold, and 11 states require donor disclosure only for donors that have earmarked those donors specifically for that specific expenditure. The remainder of 15 states do not require disclosure for express advocacy communications. The second communication I'll talk about is electioneering communication. Any broadcast, which is electioneering communications, is any broadcast, cable, mail, print communication that refers to a clearly identified candidate and is publicly distributed within so many days of an election. 13 states require general disclosure above a specified monetary threshold for those groups running the ad. 9 states require disclosure only for donors who have specifically earmarked their donations for the purpose of making the electioneering communication expenditure. And the remaining states either don't require disclosure or they just don't have laws regulating electioneering communication at all. And the last communication I was going to mention is issue ads. Now, those communications or ads focus on issues rather than specific candidates. Those ads are intended to inform the public on broader issues in general. Issue ads are protected by the First Amendment guarantees of free speech. This means that the sponsors of issue ads are not required to disclose the sources of their funding, and there is no limit on the amount of money any individual, union, or corporation can contribute to an issue ad campaign. Therefore, in no state are the laws currently applied to ads that don't mention candidates or ballot measures. Now I'm just going to very briefly talk about Virginia disclosures.
Mr. Chairman.
Who needs to?
Yeah, we have I think we have a question from Senator Surville.
Thank you, Mr. Chairman. Thank you, Ms. Zamarripa. I appreciate the information. I had a series of questions about where other states were on some of these things that you just went over. I'm aware that there was just recently a U.S. Supreme Court case that had to do with, I believe it was an effort to require the disclosure of donors from 501c4 organizations. Do you have an opinion as to whether or not states are constitutionally prohibited from requiring any type of registration, filing, or donor disclosure for expenditures made by 501c4s within the Commonwealth, even on issues relating to state policy issues?
Mr. Chair and Senator Surville, I do not have an opinion as of yet. The case that you're referring to, American Prosperity, that wasn't a campaign finance case per se. In that case, the California had required 501cs to disclose their top funders, and it wasn't used for to be out in the public. It was mainly for administrative reasons, and the Supreme Court had come back and said that the state of California's reasoning for those disclosures was not, it wasn't significant enough to warrant those protections of the First Amendment. So at this point, we are unsure how this case or others may play into the requirements or the ability to require disclosure or non-disclosure of donors for 501cs. And I apologize if I didn't know if I caught the rest of your question.
No, I think you got it, Mr. Chairman. Follow-up question.
Senator Surville.
Thank you, Mr. Chairman. So I think what I heard you say is that it's not clear that the door is necessarily completely shut, but it's possible that if a state required some sort of registration or disclosure for 501c4s and built a proper record for it to justify it, that could possibly satisfy First Amendment muster, but the case law isn't very clear on it because the Supreme Court just decided this. Is that a fair characterization, what you said?
Mr. Chair and Senator Surville, that is correct. At this point, we are unsure.
Okay, Mr. Chairman, I had another question and some other stuff.
Senator Surville.
Thank you. You referenced coordination as being sort of a keystone on when different requirements are triggered in different states. And coordination is expressly prohibited under federal law. I don't believe it's prohibited. Coordination is expressly prohibited under Virginia state law. And I was just curious if you had a sense of whether there's sort of a consensus on anti-coordination rules in other states and whether sort of where Virginia stands on coordination or not.
Mr. Chair and Senator Surville, at this particular point, I will say that I'm unsure. The definition for coordination is hasn't been sort of spelled out in most states. So I don't have a good understanding of where most states fall. I will say that there are those requirements for election communications, but the definitions of what constitutes coordination is still, I would say, iffy in states. So there's no clear line right now.
Thank you, Mr. Chairman. I had two other questions, and I'll be quiet for a minute.
All right, two more questions. Go ahead, Senator Serval.
I noticed that, I believe it was last year, the state of California recently required some additional disclosure requirements with regard to LLCs that make donations. And one of the trends that I've seen is that, I think that both on the expenditure side and on the contribution side, the increased use of limited liability corporations, and there's all kinds of things you can mask behind a corporate shell like that. And I know that's why California passed, I think, their statute that requires additional disclosure requirements when it comes to any corporate expenditures like LLCs or non-stocks or other things. Are there any other states that you're aware of have taken a tack that require the additional disclosure requirements for incorporated entities that either receive expenditures or make contributions?
Mr. Chair, Senator Serval, there are a variety of states, and I don't know specifically, but like I mentioned, 40 states have requirements, for disclosure. All 50 states have some form of disclosure or reporting requirements. I don't know the specifics on each of those states. I can look to see later on if I can find out more information on specific states and get back to you.
Thank you, Mr. Chairman. I would appreciate that, Mr. Chairman. Final question.
Yep.
Thank you. Ms. Zamaripa, my last question on this area has to do with federal committees. And I think any of us that receive the volume of emails that we received today from a gazillion different entities are aware of the fact that there's a lot of these little, I don't know whether they're little or not, but there's a lot of these organizations that seem to have popped up soliciting money all over the country for all kinds of things. And they have about 10 different variations for every campaign and every candidate and every issue. And it's my understanding, I believe, that in some states they require state registration of those federal committees. Whereas in Virginia, I don't believe that we do. Are you aware of sort of whether Virginia is an outlier on that in terms of these committees that are incorporated in Virginia that raise money nationwide, spend money outside the state? Are you aware of whether there's any other states that require the registration of those committees in their state, or whether we're sort of outside the norm on that?
Mr. Chair and Senator Serval, I'm not sure if Virginia is an outlier. I do know that there have been some states introducing legislation, and I don't have the numbers on whether those legislation has just been introduced and or enacted. But there has been more legislation I've seen. I just don't have the numbers that require for a company or a corporation, union, or others to be registered to do business within the state. And once they are registered with the state, to have requirements on what needs to be disclosed and have disclaimer requirements. But at this time, I don't have specific information on that.
Great, thank you.
Thank you, Christine. You said that you have the capacity to do some additional research after today's meeting, so maybe a couple of things that you could, if you're willing to follow up with us on, would be great. But go ahead.
Thank you. I will move forward. And I'll start talking about, I'll turn now to contribution.
Christy, I think you want to go back a
Yes.
slide? I think there was some stuff on that slide that I don't know that you talked about that I was curious to hear your take on about Virginia's specific requirements.
Oh, Virginia, I'm sorry. So I was just mentioning that those that need to disclose, candidates, parties, political action committees. Virginia does have definitions of what constitutes contributions and expenditures. Virginia also has definitions of independent expenditures. The only things I wanted to point it out was in Virginia, individuals, corporations, political action committees, and other group entities must disclose independent expenditures. Any person, candidate, campaign committee, or political committee that makes independent expenditures in the aggregate during the election cycle of $1,000 or more for a statewide election or $200 or more for any other election must report all independent expenditures. Independent expenditure disclosure reports are due within 24 hours of making that expenditure or within 24 hours of the expenditure being circulated or dispersed, whichever is earlier. Now I'll turn to contribution limits. While state contribution limits are what matters today, it is just worth noting that there are federal limits set for federal candidates based on who is giving to whom. This slide just shows the current contribution limits for the 2021-22 federal elections. You probably know that the limit for an individual can give to a federal candidate is $2,900. I'm going to talk about contribution limits from individuals to candidates. State regulation or limits on contributions vary a great deal. I will look at 4 potential donors and what they can give to candidates. There are other permutations, such as how much can be donated to a political party, but I have not included those. There are 10 states, including Virginia, that impose no contribution limits on individual donors to candidates. The other 40 states restrict the amount of money that one individual can contribute to a campaign. There are limits. These limits are typically dependent upon the office the state seat, the candidate seeks. For example, in Connecticut restricts the individual spending of $1,000 for a candidate in a state Senate seat or a state Senate race, and $250 for a candidate for a state House seat per election. Now, what is high, low, and medium of state contribution limits from individuals to state legislative committee to state legislative candidates? The high is around $13,700, and that's in Ohio. The low is $180 in Montana, and the median falls somewhere between a little over $2,800. Now, oftentimes, primary and general elections are considered separate elections for the purposes of contribution limits, and this is much like federal law. Now I'm going to talk about state party contribution limits to candidates. 18 states impose no restriction on the ability of state party committees to contribute money to a candidate's campaign. New York has limits for primaries. Kansas, if it is a contested primary election, there are contribution limits. If it's an uncontested primary or general election, there are no limits. The remaining states have some sort of restriction on funds from state parties to candidates, falling into 2 camps. 6 states require parties to follow the same contribution limits established for individuals. The other states have separate limits for political parties. Now I'll talk about PACs, or political action committees. These are the organizations that pull campaign contributions from its members to support or oppose candidates, ballot initiatives, or legislation. 10 states allow PACs to contribute unlimited amounts of money to candidates. In Indiana, there are limits for contributions by a corporation union to a PAC that is specifically designated for a particular candidate. Mississippi has limits for judicial candidates. And in Wyoming, there are limits for non-statewide offices. The remaining states either impose the same limitations for those individuals or provide separate contribution limits. And the last contribution limit I'll talk to is from corporation limits to candidates. 22 states prohibit corporations from contributing to political campaigns. Another 5, including Virginia, allow corporations to contribute an unlimited amount of money to state candidates. Of the remaining 23, 19 impose the same restrictions on corporation contributions as they do for individual contributions. The other 4 set different limits. Next, I'll talk about public finance. Public financing of campaigns is the least common issue addressed by legislation of the 4 major topics that I was going to talk about. In 1976, in Buckley versus Vallejo, which I will discuss later, the Supreme Court struck down a provision mandating public financing for presidential elections. Therefore, all state public financing programs are optional for candidates. 14 states provide some form of public financing option for campaigns. There are 2 main types of programs, and that is clean election programs and programs that provide a candidate with matching funds. They're very similar. A clean election program, such as in Arizona, Connecticut, Maine, candidates are encouraged to collect small contributions from a number of individuals to demonstrate that he or she has enough public support to warrant public funding for his or her campaign. In return, the commission established for that program gives candidates a sum of money equal to the expenditure limit set for the election. So, for example, in Arizona, participants agree to forego any special interest or high dollar contributions. A candidate for statewide office must raise $5 contributions from at least 200 people in order to qualify for the program. In return, the state provides the candidate with public money in the amount equal to an expenditure. So for a state Senate seat, the expenditure limit would be around $25,000, a little over $25,000. The other type of public financing program that I mentioned before provides matching funds for candidates up to a certain amount. The candidate must agree to limit expenditures to a set amount. So, for example, in Hawaii, a candidate running for a state Senate seat must agree to an expenditure limit of $43,540 for each election, primary and general. A minimum amount of qualifying contributions of $2,500 must be raised by the candidate during the primary matching payment period to be eligible to receive an additional $2,500 in public funds for the primary election. The maximum amount that public funds that would be available for a state Senate seat is 15% of the expenditure limit, or around a little over $6,000 per election. Now, it's just worth noting that for public financing options out there, they're not available for all offices. And this slide is to show you that there is variation. There really are 5 states that allow public funds for legislative races. So this is the last major issue in campaign finance regulation, and that's enforcement. Whether liked or not, good, bad, money is part of the American political process. And even before the country gained its independence, money, or at least what could be bought with it, has played a part in politics. Legend has it that George Washington enticed political supporters with beer, wine, and other libations for his 1757 bid to be an elected representative. As the federal government and states began to regulate money and politics, how to enforce those regulations became a question. Just as laws and procedures governing campaign contributions, expenditures, and disclosures vary widely, so do state enforcement mechanisms. Depending on the state, and campaign finance reporting and enforcement may be handled by secretaries of state, commissions, boards, or attorney generals. In the last 5 years, all 50 states have introduced legislation relating to enforcement. 37 states, including Virginia, have enacted bills during that time period. In Virginia, reporting and enforcement are handled by a mix of local and state entities. Finally, I'm going to just discuss.
Hold on one second. Senator Servo.
Thank you, Mr. Chairman. Ms. Zamarripa, I had one quick question about enforcement. I know one of the things that's come up in the conversations has been audits. Are you aware of how many other states do routine audits of campaign finance filings? And obviously, to do that, we'd probably have to find some funding. Are you aware of any states that require people to pay a filing fee with every time they file a campaign finance report?
Mr. Chair, Senator Serval, I believe that nearly all 50 states have some kind of disclosure and reporting requirements. Now, whether there are fees associated with audits, I'm not sure, but for most states, there is at least a nominal fee associated with reporting. But I'm not sure, and I can look on it further to give you a more concise answer.
Thank you.
Mr. Chair.
Delegate Bulova.
Thank you. And I guess just to follow up on Senator Serval's question, because I think the one that I'm most interested in is just the number of states that have some kind of advanced or any kind of auditing process, whether that's random or however that's done. But can you give me a sense of how many other states have an institutional or agency that goes out and audits and then follows up with either some kind of training or enforcement if the filings are found to be inadequate or inaccurate?
Mr. Chair and Delegate Bulova, I am not aware, I don't have the specific numbers of how many states have an auditing process and what that process is. But I can look into it further and see what information I can find and send that at a later time.
Great, thank you.
Mr. Chairman.
Senator Bulova, Senator Favola.
No problem. A related question, but I don't think we've covered it head on. Do you know of states that actually provide technical assistance or issue opinions and advice to candidates before, say, an enforcement notice is issued? In other words, is there a due process, if you will, and maybe related to that, is there a technical assistance piece to some of these enforcement models? And you don't have to answer that today, but it is something I'm interested in and would like further conversation on if that is the will of the committee.
Mr. Chair and Senator Favola, at this time, I am unsure of how much technical assistance or other stuff is given from those enforcement entities in the different states. I just know that the enforcement varies quite widely for each state, and which entity has the ability to enforce in their respective states. But I can look into any information I can find and send that later on.
Thank you. I think we'd appreciate that. I think you're getting a sense from us of some of the issues we want to dig a little bit, drill down a little further on with your research expertise. They got Delegate Scott, I think, has a question for you.
Thank you, Mr. Chair. Is there, I guess I'm the only freshman here, I think. And I know when I was first running, it was a daunting task to try to figure it all out. And just recently, we've had several candidates in the last cycle that couldn't get on the ballot for whatever reason. Is there any other states that do some minimum amount of technical assistance and or training prior to once someone declares to be a candidate, so that they can tap into some of the information? I know we have a package that we get from our Department of Elections, but it would be nice to have some type of PowerPoint presentation or some kind of video that we have an orientation or something that they can at least go to and review if we don't already have it. And I was just wondering if other states do some type of that. I know I've been on hold many times for our folks. I love them to death, but it's very difficult to get that help. And I was wondering if there are other states that do that.
Mr. Chair and Delegate Scott, as mentioned before, I don't have the specifics for each of those states. I do know that there are states that do have guides or manuals, but as to the specifics, I don't have that information.
All right, thank you. We'll see if we can get some follow-up on that. I think we may have some folks in our public that may have some information on some of these issues too, maybe able to enlighten us here in a little bit. All right, did you want to go ahead and jump into the court decisions and sort of breeze through that for us? Because I think we have.
Sure, absolutely. All right, so I'm just going to talk about a few the key cases. Buckley versus Vallejo. In that, the court held that contribution limits are constitutional. Expenditure limits are not. Restricting expenditures if the court found restrains free speech unconstitutionally. So setting limits on contribution, however, is justified because it may prevent the corruption or the appearance of corruption. In the Nixon case, the court held that states can also limit the amount of money that one individual or group can contribute to a state campaign. The test was whether any showing that the limits are so low as to impede the ability of the candidates to amass the resources necessary for effective advocacy. The next case, the Randall in 2006. Randall struck down an existing Vermont contribution limit.
Your slides are one off from what you're talking about, which is okay.
Oh, I'm sorry. Oops.
You're one slide behind or you were ahead, depending on how you look at it.
Okay, let's see. Oh, must have. Let's see if I can. Oops. Now, excuse me, as I somehow got off.
There you
go. Okay. So, talked about Nixon. Randall.
Nixon before when the other one was up. So.
Okay. So, well, Nixon, as I mentioned, that states can set a limit of the amount of money that one individual or group can contribute to a campaign, and the test was whether that the limits are so low, showing that the limits are so low to impede the ability of the candidates to amass resources necessary for effective advocacy. In the Randall case, that case struck down an existing Vermont contribution limits. It was $400 for a candidate running for governor. The court found that as unconstitutionally low. And they said that it prevented candidates from amassing the resources necessary for an effective campaign advocacy. So as a result, states must now not set their contribution lows so low as to make it difficult to run a campaign given all its related expenses. Citizens United, now this famous case made it clear that states cannot place limits on the amount of money corporations, unions, or PACs use for electioneering communications as long as they don't coordinate with a candidate. This gave rise to independent expenditures. And finally, just briefly talk about McCutcheon versus FEC. States cannot place limits on the aggregate amounts individuals, corporations, unions, or PACs can use for electioneering communications. Before the ruling, 9 states had imposed aggregate contribution limits on the overall amount any individual or group could contribute to all candidates. Limits on the total amount of money any individual can contribute during the election cycle violated the First Amendment and therefore was unconstitutional, but limitations on the amount of money an individual can contribute to a specific candidate remains in place. With that, here are just a few other ways to stay connected with NCSL. NCSL maintains extensive resources on various aspects of campaign finance, from state disclosure requirements to public financing programs and limits on contributions to candidates. Here are just a few resources and web pages that are available from NCSL. So with that, I thank you for your time. I'm happy to answer any additional questions now or at any point. Please note that any questions that come by email or phone are handled confidentially. Thank you.
Thank you. A quick question for Rashana. Are these slides available? Are they going to be posted on the LIS or somewhere where folks can pull them down?
Yes, the slide will be posted to the interim studies website.
Okay, thank you.
Mr.
Senator Servo?
Thank you, Mr. Chairman. I have one other question based on what you just talked about there. Ms. Amaripa, so you talked about legal restrictions, or I guess constitutional restrictions the Supreme Court has found. Are you aware of whether there are any constitutional or legal constitutional restrictions on our ability to require larger donors to have to disclose different information than smaller donors? So, for example, say somebody wanted to give, or a company wanted to give a large amount of money, perhaps they would have to disclose additional information about themselves or their finances or something like that, that other smaller donors would not have to disclose. Are you aware of any constitutional restrictions on that type of policy?
Mr. Chair, Senator Sobel, there are no restrictions. Just keep in mind that the Supreme Court has mentioned that contribution limits and disclosure requirements to a specific candidate is acceptable. Restrictions for expenditures is not. But in terms of disclosure, I don't know of any specific states that have a disclosure requirement specific to large versus small donations. I believe most of the donation requirements are more on the larger contribution side.
Great, thank you.
Thank you. All right, so everybody has Christy's contact information. She flashed her cell phone number up there for a minute. I'm not sure how good an idea that was, but it works. You've all got it if you wrote it down. So, and it's on the slides. So thank you so much for your time, and we look forward to hearing back if we can with some of those follow-ups. And again, commissioners are also free to follow up directly if you want to get a little more into things. What I'd like to do, if it's okay with the commission, is go a little out of order. And I know we've got some public comment. We've got a lot of people signed up for it. But if it's okay with you guys, I'd like to hear from Nancy Morgan with American Promise. They produced this fairly comprehensive report. And if it's not putting you too much on the spot, Nancy, you were nodding your head sort of vigorously, and you look like you might have some answers to some of the questions. Would you mind spending maybe 5 or 10 minutes just walking us through your report here real quick? I think I have to.
Report, and just to let you know, we're a group, and most of the room are from our group. Anyway, I'll just make some comments, and thanks to Marcus, and thanks for the committee, actually, for having its first meeting. And I just want to start off similar to the NCSL, just to highlight some facts. So we've been waiting 30 years for campaign finance. Basically, the Wilder Report came out in 1994, committing to campaign finance limitations, followed by the McCullough Report. And when we were looking at this in our report, we decided, okay, let's see, since 2015 over 2021, how many bills on campaign finance have been introduced into the General Assembly? 123 bills were introduced, 19 were passed, and all of them were all minor adjustments to reporting requirements to the 2000 Disclosure Act. And all of the bills that were substantive issues related to public financing, banning corporate contributions limitations, were banished basically to the rubbish bin of history. So that's basically why our group sort of said, let's just take the next 3 months and try to figure and do an analysis. And obviously, as the NCSL said, we're one of only 5 states with no limitations. Oregon actually is trying to introduce limitations right now with Utah, Nebraska, and Arkansas. And it's not surprising that we're number 36 on the Swamp Index, just in terms of transparency and accountability. Meanwhile, we actually looked at, on VPAP, they actually had some interesting data that we extrapolated. The average contribution to our legislators running for office is $25,000, 66% of contributions over $25,000. I'm sure people in this room, we're not the ones that are doing that. And then according to Open Secrets, which sort of joined up with Follow the Money, we dumped some data that said average contributions from non-individuals in Virginia average 85%. So that's from basically political parties, PACs. That's not from you and I and Josh back there. And when you compare it to national averages, that's 15% over national averages. So it just shows the context of not having limitations and how much money going into our election. And right in front of you is our report that we've been working on. When you look at the agenda, it sort of followed what was presented today. We did look at the history of campaign finance reform in Virginia, weaknesses in Virginia law, critical elements of reform where we had actually, what does comprehensive campaign finance look like, and we have 3 buckets. Basically, we have transparency, which is actually disclosure, accountability, which is the enforcement issue. And then we had a big discussion with the Campaign Legal Center and we said leveling the playing field, and they said, no, that has legal implications. So we said, promoting integrity for fair play. So there are 3 buckets. And then what we did was over the last 6 months, we've been having listening sessions with legislators. So you guys have been very generous with your time. What do you think about campaign finance? What makes you uncomfortable? Where do you think what can be passed? And most importantly, a section on legislative packaging and sequencing. And this goes to the issue of, and I thought you were going to talk about Marcus Simon's bill that went through the House 100-0 and then died in the Senate. And after a lot of thought about that, that bill actually highlights the challenge for Virginia. And looking at Scott Soroval's and Jill Vogel's, what they did on the floor of the Senate, I realized afterwards it reveals the fact it didn't pass the Senate because Virginia doesn't have the institutional structure capacity to provide regulatory oversight. It shouldn't be you guys writing on the floor and the bill. You shouldn't be deciding what you can spend your money on. Or it showed that there's a tiered approach towards building a solid foundation of campaign finance that's built on oversight and accountability enforcement. So we think it's really appropriate that this year we're probably going to have the most expensive race in Virginia in our history, and we're excited this committee is getting off the ground. We're hoping that your proposed analysis and strong recommendations, but we're also concerned about what's happening in the press and some of the comments about saying maybe you need to push it back. And we recognize as citizens that you guys have a lot of responsibilities, especially now with redistricting. I know Senator Deeds is very concerned about mental health issues. However, we really hope that we spent like 3 or 4 months working on this report, and we actually met with best practices. We met with Oregon people. We met with Washington State, their Public Disclosure Committee. Minnesota has a great campaign finance board. New York City actually has the best system. It's also public financing of elections. And we met with the Maryland guy. They're under the State Board of Elections, and he said he's happy to work with you. They have great disclosure bills, and he's happy to testify and provide technical support. So we really think that we're excited about working with you, and we encourage you, to look at setting up working groups and bringing in people to testify, and in anticipation of getting some legislation passed next year. So thank you. Thank you, Marcus.
Thank you, and again, thank you for the report. And for those of you that haven't received, I got it prior. It is very thorough. It does answer a lot of the questions. It goes into a great deal of detail. And I think we'll probably want to refer on her page 13 when you talk about the sequencing as we get to the point where we're going to develop sort of a work plan for ourselves to figure out what to do next. I did have a question, maybe for counsel, for Brooks. I put him on the spot here because I didn't tell him I was going to ask this before. But on page 4 of their report, and I think we heard about this a little bit in the NCSL, I thought I passed a bill that did this, but it says existing laws do not require disclaimer requirements to be included on online advertisements in Virginia. I thought I passed a bill that did something. Did it not go far enough, or do you know what I'm talking about, Brooks?
Yeah, Mr. Chairman. Virginia law does require disclaimers on anything printed on a website, for instance, or something like that. There are certain loopholes. So, for instance, if you acquire a free Facebook page for yourself, because it's free, you can say whatever you want on that platform. You don't have to disclose it. But if you pay Facebook, for instance, money to circulate a particular ad, that ad does fall under the print media disclosure requirements.
Thank you.
Mr. Chair.
Thank you. Delegate Bova.
I guess I had 2 questions, and maybe to follow up first on the social media one, because I was trying to follow what NCSL was talking about in terms of the digital or the social media, and maybe somebody can help me maybe pinpoint the weakness that NCSL was trying to highlight as far as one of their many issues. And so I don't know if Christy is still on, or maybe Nancy can go ahead and answer this, but given that there is a requirement in the law, what is the area, what are the loopholes that are, I guess, being exploited that we might need to take a closer look at?
I'd like to call on my colleague.
Phoning a friend.
Good afternoon. I'm Karen Greenaway. You probably remember me as the poster child for rural broadband because I'm out in Port Royal, so most of the time you just see my name on the screen as opposed to actually hearing me. So in answer to your question, the challenge is, of course, it's the enforcement issue, is that, there is a fine, but again, that falls under, as I understand it, State Board of Elections, and State Board of Elections has zero capacity to address these issues in violation. And so, in talking about disclosure in general, the challenge in Virginia is that we don't have any real true enforcement. It goes from, State Board of Elections, might find a discrepancy or an issue, they refer it to a Commonwealth attorney. But if it's an administrative issue, if you made a mistake, it's not some sort of criminal issue, there's nothing that happens. So that's really what it boils down to, is that we might have a good law, we might require disclosure, but if somebody's violating that, the State Board of Elections doesn't have the capacity to assess, to really take a look at that, to assess fines or have a transparent complaint process to make sure that a fine gets assessed.
Okay, thank you. And Mr. Chair, if I could have one last question.
Delegate Bova.
Thank you. And so I guess for that one, it sounds to me like we have a good law in place. It's just a matter of actually enforcing it. I guess another thing that I saw in your all's report that got covered in the NCSL one, but I think it went a different direction as far as where they were taking it, because NCSL mentioned timing issues, and I guess for them the timing issues were whether you can take contributions during session. It didn't talk about special session, but I imagine that's kind of that same bucket. But I think your report talked about timing from a different perspective, which is our timing calendar, or our reporting calendar in Virginia on the right track, or nimble enough or flexible enough to make sure that things are reported in a timely manner before, whether it is a general election, a primary, or for parties that use things other than primaries for their electoral process. But I was wondering if you could talk a little bit more about the timing issue that you were raising, and what would need to happen in order to fix that.
Sure, I think that everybody, the consensus is basically you shouldn't be raising money during special session. And I know, again, I'm going to turn it over to Karen, because I think when we were talking to the New York City Board of Elections and also some of these other organizations, timing is always a big issue. And Karen, you want to address that?
So the timing issue, so you have the disclosure part of it, which is 48 hours, but then there comes the question of how far out from election do you want to cut off or limit, limit contributions that can happen. Some states, what they do is say, like, for example, 7 or 14 days out from election, that that you can't make a contribution during that time frame, within 7 days of the actual election date. New York City said that they didn't feel like the Campaign Finance Board felt that they couldn't, that I should rephrase that, that they actually, that was an issue for them, that they didn't have some sort of limitation on, the timing being before an election or a special election. And then the other issue, of course, is then separating not just the election itself, but selection of a candidate, and are you going to make a distinction between, party selection process, donations, and then candidate election process. So it's really two things. It's the special session issue, allowing you all to raise money during special session, but then also the timing of how far out from the actual election date do you allow contributions. And some states are concerned that they have not done enough to regulate that, so that you see lots of money coming in at the last minute to sway elections either way. And obviously then whether or not you can really limit that to the point, that regulation, wasn't really something that we really truly drilled down into. So it might be that you can say 3 days out from election, nobody can contribute. But we didn't look at that specific point technically. We just heard that from others. And to your point, Delegate Scott, if I could just answer your question about the technical assistance. Maryland has not just training, but they also have YouTube videos that they put out. So that, and then Minnesota actually has hotlines for treasurers, that you can call. So they have, so you have, in fact, the Minnesota, Campaign Finance Board said that they considered the treasurers to be their most important contacts in campaigns. So they make sure that they are in regular contact with treasurers to make sure that they are getting what they need, that they're having any issues, like a technical assistance. Connecticut actually has like reminder emails. They'll send you out an email, hey, this is due at this date. If you have any questions, they're not enforcement staff, they're not lawyers. They're just, staff who may have worked at the legislature, who sit and man phones to send you all kinds of reminders to make sure that you're in compliance. So it's kind of like having like a help desk. Several other states actually do that, and some of them do it very well. And we advocate for that because we're not here to get anybody. We're not looking to create a system that gets anybody in trouble. We just want to make sure that everybody has a better system so that we can see more transparently what it is that's getting filed and how it's getting filed. And I think there's a lot of, opportunity out there to take what other states have learned related to that and incorporate that in Virginia.
Thank you for that. Thank you. I think that's a good question, Delegate Scott and Delegate Bull. I think to the extent that we start to talk about ramping up penalties and tightening up deadlines and things, we also need to remember that a lot of our campaigns are relatively small and many have no paid staff at all. And so you got to be able to provide a resource if you're going to hold folks accountable for missing deadlines and technical violations. Let's at least give them the resources to avoid those mistakes in the first place. So I appreciate that. Senator Favola. Senator Favola.
Right. I know you want me to be part of both houses, and I appreciate that. I treat that as camaraderie. In conversations I have had with some of the folks who are really following this issue very closely, I know, Nancy, you have been in conversation with me on several topics. On the issue of transparency, I'm really trying to understand what additional platforms or venues we should be using to buttress the transparency point here, because we do have VPAP. When reports are filed, they are made public. Are the venues not public enough? Is it an issue of reports not being understandable or not being accessible? And what would your recommendations be? Because that's sort of a big part of your transparency argument as I'm reading page 4.
Yeah, I'm going to call Karen up, but I can tell you as a citizen, I love VPAP, and I give them $10 a month. I'm paying for disclosure. But I would just like to say, when you go, I said, I'm going to go to the State Board of Elections and try to pull off some of the data. There were millions of CSV files, and there was no guidance. I contacted the people. I said, do you have any guidelines on how to use this data, how to pull together information? I was just trying to figure what are actually the costs of Virginia elections, because you can find it piecemeal on VPAP, but I'd really like to turn it over to Karen because we just had a discussion about this yesterday, and I know it is in the report, and she actually had it in her testimony.
So the challenge with VPAP is basically it's a private entity, right? It's a not-for-profit. It's not a government entity. Every other state that we looked at, that's a government responsibility, a government function. And so some states, have created their own, campaign finance reporting platform. Other states have borrowed from, already created programs and adapted those programs. As our understanding as to the way VPAP works is that it gets that data directly from the State Board of Elections, and that they then take that data, and bring it into more upgraded files that they then use to create what we see, in the report, in their reports, and it's very good, but every other state, this is a state responsibility. They don't rely on a private entity to be, the transparency arm on campaign disclosure in the state. And so, that's that file that we're seeing. Is an older type of file. There's all kinds of ways to upgrade that so that we get, you fill out a Google form and it goes into a more upgraded system. And it's much easier to then, what we call in the civil advocacy world, called data curation, to look at that, as not just an individual citizen or anybody else. Right now, VPAP does essentially the data curation for this state. That's not the way it is in every other state. So VPAP uses upgraded technology. It's that the data that they get from the state is in older technical formats. And so we need to move Virginia into, a more advanced technical format, so that, not saying that data, VPAP can't continue to do what they're doing. It's just that, it should not be so difficult for an individual citizen like Nancy or myself to try to figure out how much was spent on any one election in a year by pulling that data from government data, because it is government data, right? It is public data. It is, our taxpayer dollars support, the system at State Board of Elections that collects that data. And in every other state, that collection of data is done by the state, and taxpayers pay for that transparent system so that the public can see. And that's also how, frankly, the public, checks and sees whether is there an ad that was paid for illegally, or, and we realize that's probably a later conversation about, concerns about, frivolous complaints, and we've written about that in our report too. But it's a way for the public also to understand, better, and have have a better ability to just check and make sure that, that what is going in there and what we're seeing is following the law.
Thank you.
Mr. Chair.
Delegate Bagby.
Yes, and I don't know how to ask this question, but it appears that you know who, and forgive me for saying it, these folks are, and I don't.
Sure.
And so, as we talk about sort of disclosure, like I may understand individually, but is this some sort of commission or committee that's speaking to us right now, or is it individuals?
So, yeah, thank you, Delegate Bagby.
We're affording them a great deal of time.
Sure, and I think I was about to, and I appreciate that.
I'm not telling them the end. I just want to know
who they are. So, Nancy, do you want to go ahead and tell us a little bit? Again, y'all produced this 13-page report. Your big money out is how you're known in Virginia, but tell us a little bit more about your organization and your background. And then I probably will want to move on with the agenda.
Okay, and thanks for that. In fact, our group started as a Virginia chapter of American Promise. American Promise basically looks at promoting a constitutional amendment to allow the states and Congress to regulate election spending. But in discussions with legislators and looking at the Virginia context, and Senator Deeds was very he participated on Constitution Day. The two sides of campaign finance are the federal issues, which are a mess, and also campaign finance in Virginia. So that's our group. Is basically, it's a citizens advocacy group that we're all volunteers and we care about this issue. So we've, over the last 3 years, this is what we've been doing, and the last year we've just focused on pulling together this report. So I hope that's enough. If you have any other questions.
Yeah, and Mr. Chair, I might just get with you afterwards, because I just want to make sure that if I have constituents or individuals that live in my district or around my district that may want to engage with you all, then they can possibly engage with you all. And then also, I guess I'm not able to get any internet service in this room, so I was trying to go on the website to see what sort of board or commission that you all have
Okay,
set up.
we're not an official. We're just a volunteer group. We do have a website. We have a contact. When you go on the website, you can contact us. We're nonpartisan, and we're trying to build advocacy around the state. So we would be happy if you have constituents are interested in this issue. We're happy to talk to them because we think it's a really important issue.
Yeah. And to be quite frank with you, what made me think of it is oftentimes when we have these meetings, we look up and we look for diversity in the room. And this is one of the things I want to see how we can get some diversity in the room.
Absolutely, and we'd love to work with you and build that diversity and knowledge around the state. So thank you, Marcus.
Thank you, Delegate Bagby, and thank you, Nancy. So what I'm going to do, if it's okay with folks here, I want to table for just a minute the discussion of personal use. We put personal use and the history of the legislation there on the agenda. In part in case we didn't, we ran out of things to talk about, because I think there was sort of a consensus during the regular session that was an issue that we wanted this commission to take a look at the end of the session. I think we can come back to that before we leave today and see if there is in fact an appetite to try and figure out the best approach and start to workshop a bill, a specific piece of legislation we can all support that addresses some of the concerns that were raised about unintended consequences from what I view as a fairly simple idea of banning personal use of campaign funds. But before we do that, we do have a number of other people that are here and some people that have signed up. So if it's okay with the commission, we'll go ahead and move into public comment. Make sure everybody who wants to talk to us has a chance to tell us what issues are important to them. And then if we have time at the end, we'll come back to personal use. So hearing no objections to that, I am going to, so Nancy and Jessica were the first two people on my list. So I'm going to move to the next person, who is Janet Boyd with the League of Women Voters. Is Janet here or is she online? Or do we need a minute to get the people that were online into the queue?
Mr. Chair, Janet is online, and I believe she's ready to speak.
Janet, are you ready?
I am ready. I'm trying to get my video up. There we go. Thank you so much. I appreciate this opportunity to speak, and I very much appreciate.
Before you start, if you don't mind, I'm sorry. Let me lay out some grand rules. We did give the money out, folks, a great deal of latitude here because we had a report in front of us. We wanted to make sure commissioners had a chance to have a back and forth. But if those of you that are signed up to speak could keep your remarks to about 3 minutes or so, I would appreciate it. And if you've heard something spoken about from a prior speaker, you don't need to say it again. You can certainly associate yourself with somebody else's comments. But with that, Ms. Boyd, you're first, so you don't have to worry about that problem. So if you go ahead, I'm sorry to interrupt.
No problem at all. Thank you. Again, thank you, Mr. Chairman and members of the Joint Committee for this opportunity to testify on behalf of the League of Women Voters of Virginia and its 14 local leagues serving voters throughout the Commonwealth. My name is Janet Boyd, and I am a member of the League's board, but I also am leading the organization's effort to study Virginia's campaign finance rules. We are in the process of undertaking a 2-year study of campaign finance reform in Virginia, so we will be continuing to provide input to you during this process as well as in the future. Currently, as we've been hearing all day today, the Commonwealth's campaign finance laws are inadequate. As was highlighted, only 5 states, including Virginia, have no restrictions on any campaign contributions. The League has long believed that campaign finance rules can enhance political engagement for all its citizens, as well as serve both to protect representative democracy and combat corruption through transparency. Last session, as you might remember, we supported Delegate Bolivar's bill for setting up the joint subcommittee. We also supported your bill, Chairman Simon, to eliminate the personal use of campaign funds, as well as a number of bills to limit dollar amounts of campaign contributions. We continue to believe and support the edict of this group to provide a comprehensive review of the campaign finance rules in Virginia, and we believe this covers 5 basic areas. The first is restrictions on who can contribute. The second is limits on campaign expenditures. The third are restrictions on donor contribution levels. Fourth, enhanced disclosure of contributions and spending. And finally, the enhanced enforcement capability. Our report that we're working on will cover each of those 5 areas. And so we will be willing to provide input on each of those areas as you consider them by this subcommittee. The League of Women Voters of Virginia is committed to supporting and assisting you in any way we can. Thank you very much for your time.
Thank you, Ms. Boyd. Next up, we have Michael Pan, and he's followed by Mike Hatfield. So, Mr. Pan?
Mr. Chair, it doesn't seem as though Michael Pan is online.
All right. How about Mike Hatfield?
Mr. Hatfield, could you please unmute your microphone?
I am online.
We can hear you. Very good. You're free to proceed. If you want us to see, you can turn on your video, but you don't have to, but you're up. Oh, you muted yourself again.
Are you ready for Mike Hatfield?
Yes, Mike Hatfield, you're up.
Good afternoon, Mr. Chairman, and thank you very much for this opportunity to voice my support for campaign finance reform. I will certainly abbreviate in order to avoid redundancy from other things that have been said. Mr. Chairman, when you began the meeting, you talked about Virginia as an outlier. That would be one of my main points. it's clear from the NCSL presentation that Virginia really is an outlier. In addition to what Christy had presented, it's clear if you look at just the adjoining states to Virginia, all 5 of those states have some limits on both individual and corporate contributions. But to cut to the chase, I think from my standpoint, speaking as an individual, we know we can't take money out of politics. It's a form of protected free speech according to the courts. And voters have a right to know where their candidates stand through communications that cost money. But I think it's time that we follow the lead of other states and let's take money out to the extent that we avoid the potential for corruption and conflict of interest, the squandered time that you candidates spend gathering money. And for me, the real loss is, absent any kind of reform, is that if we don't set limits, the public trust will be damaged. It's true for me that elected officials are acting in the interest of all families, friends, and neighbors, we would hope, but that may not be the perception if it's just the ones with deep pockets that are getting the attention. So please, with all due respect, let's let comprehensive reform begin now. Let it begin with you and take action to set dollar limits. Thank you very much.
Thank you. Next up, we have Jeffrey Jacobs.
Mr. Chair, Jeffrey Jacobs is not in the room.
Okay. Next, we have Bill Millhauser. I see Bill Millhauser online.
Okay. See if I can. Can you hear me?
We can hear you and we can see you. You're up.
All right, thank you. Chairman Simon and members of the committee, my name is Bill Millhauser. I'm a Fairfax County resident and a volunteer with Virginia chapter of American Promise. Virginians have been waiting almost 30 years for real campaign finance reform. However, almost every serious effort at reform has failed, leaving us with our present weak and largely ineffective system. I urge the committee to take action over the next several months to put Virginia on the road to a more effective system, which instills public confidence that our elections are not compromised by the influence of money. I therefore commend you to our citizens' report on the need for comprehensive campaign finance reform. I'm really not going to get into the details because of the presentations of Ms. Morgan and Ms. Greenaway provide you a really good overview of our report. I will say that it looks at the gaps and loopholes in our current system and provides recommendations to address these deficiencies based on a review of what's going on in other states and at the federal government level. I urge the committee to expeditiously move forward in 2 areas: addressing the glaring lack of restrictions on the personal use of campaign funds, as we've discussed earlier today, and implementing much needed improvements in the transparency and accountability of our campaign finance disclosure laws. You've heard a lot about that today from Ms. Greenaway. The details are provided in pages 6 and 7 of our citizens report. The discussions on this issue should include the consideration of a budget item to begin implementing these improvements. Thank you for the opportunity to speak today and consideration of the citizens report. Thank you.
Thank you, Mr. Millhauser. Next up is Grace Patton.
Mr. Chair, Grace Patton is not in the room.
Okay. And then next up would be Stephen Spitz.
Can you hear me?
We can hear you and we can see you, Stephen.
Thank you, Mr. Chair. I wanted to emphasize 2 things. One which has been raised and another which has not been raised in this meeting. The one that has not been raised is a bill which I believe will be introduced again to ban the use, the donations from public service corporations to politicians. As we know, there's an inherent conflict of interest in having Virginia Public Service Corporations, which are regulated by the state, in making campaign contributions to the very regulators that are supposed to be regulating them. That would be the Virginia General Assembly and the State Corporation Commission. This was a bill that was considered by the subcommittee of campaign finance, but was rejected. The other area, as we heard from the NCSL, Virginia is one of only 5 states that allow unlimited contributions from corporations, and only one of 10 states that have no individual campaign limits. Campaign limits are key. I note that Buckley versus Vallejo in 1976, 45 years ago, said that contribution limits are constitutional, and that has never been overturned. Citizens United does not in any way restrict on a constitutional basis any limits that the Virginia legislature can or should place on individual or corporate contributions. So I urge you to do that next year without further delay. Thank you very much.
Thank you, Mr. Spitz. Next, we have Virginia Pannebecker.
Mr. Chair, Ms. Pannebecker is not in the room.
Okay, and then I skipped over, mistakenly at the beginning, Jessica Mott. I think I see Jessica online. So Jessica, I'm not going to skip you. Go ahead.
Okay, my name is Jessica Mott. I'm a resident of Arlington County with Rip Sullivan as my delegate and Barbara Favola as my senator. I'm a member of the Virginia chapter of American Promise and also active in the group We of Action. As I want to repeat my commending the Citizens Report to your attention and emphasize a few specifics about the pragmatic sequential approach to policy reform. We recommend that you begin with the transparency and accountability agenda through 2 legislative packages. The first legislative package would include 3 major interrelated parts. First, to enhance disclosure with improved information technology and other measures. This would make the information more complete, and it would enable easy public access and analysis to robust campaign finance data. Second, set up a regular monitoring and auditing. This would include automated IT that requires complete data and flags outliers so campaigns could make their own corrections, and it's sort of built in that. And a help desk to facilitate compliance and thresholds for complaints to avoid frivolous complaints. Third, establish the requisite institutional capacity and budget. And the second package of legislation, as we've mentioned, would in that agenda would enact restrictions on personal use of campaign funds, which is long overdue. Please note that due to Virginia's 2-year budget cycle, it is crucial to reach basic agreement on these 2 packages this autumn and then pass this legislation in the 2022 General Assembly. Implementing this full transparency and accountability agenda would represent a major step in restoring Virginia's reputation. It would also provide a fundamental building block for the other elements of campaign finance reform, which we categorize under the promoting integrity and fair play agenda, which mentions, gets into limits, it gets into a constitutional amendment, it gets into public financing. Thank you for this opportunity to testify and for your work on this committee. If done well, your work can and should strengthen the trust of Virginians in state government.
Thank you, Ms. Mott. That is it for anybody who's signed up to speak and virtual speakers. I noticed there are some people in the room. I'm happy to give 3 minutes to anybody who is sitting in the audience that wants to address the commission. If you want to make your way to the microphone, identify yourself, and you can go.
Good afternoon, Mr. Chair, members of the committee. I'm Josh Stanfield. I live in Yorktown, and I'm represented by Delegate Mullen and thankfully Senator Locke. But, you know, instead of going through what I was going to talk about, I do want to address one of the questions. I think it was it Senator Favola, about transparency and, you know, what's the problem? Essentially, it seems like we have a lot of reporting and the information's there. I've found, you know, as a citizen investigating different issues, that there is data there. But the question of whether or not that data is truthful or accurate is really up in the air. I had one situation with the delegate where there were statements of economic interest that were filed that I pulled and others pulled. And then when reporters went looking for them, they were no longer in the system. Some of us had them, but they weren't in the system anymore. That's one type of issue. Another issue is we had a local state senator do campaign finance filings and call something a contribution, and then many months later, change it to a loan. These are very different distinctions in terms of whether you get the money back. Whether, you know, that was accurate or any of the details of that, we'll never really know. And I want to give you the foundational reason, a quote from the Department of Elections. I found contributions that I knew were off and asked, you know, what's the issue here? What can we do about this? And here's what the Department of Elections told me, quote, "We don't police or audit reports." All right? If a discrepancy is brought to our attention, we refer the person to the Commonwealth's attorney in the locality that it occurs. So any citizen, anyone who might even know that something is not true the way it's been filed, really has no recourse unless you want to go to a Commonwealth's attorney who are partisan inherently in Virginia and are unlikely to go after fellow politicians. And so you're just sort of stuck and wondering, does anyone look at this data at all? How much of it is true or not? When you go to VPAP, sometimes things are reported from the original documents and they're not. And there's just this question of, you know, where's the real data? It would be great if the state had an entity that we could trust in terms of the data. Now, there are a couple other sort of obscure but stranger issues I've run across that, you know, might be of interest to you. One of which has to do with, you know, conflicts of interest in stocks. We've heard about problems with PPP loans and people having stocks in pharmaceutical companies at the federal level. But in Virginia, you know, I think the House has Rule 69. The Senate, I don't know about now, but it used to be, I think, Rule 56 that has to do with conflicts. When we think back to like the rate freeze bill in 2015 with Dominion, there were plenty of legislators who held Dominion stock who didn't go R69, didn't stay out of that vote. And that's another question. I don't know how much it's under your purview, but it's important to wonder, does this even matter? Do these rules even matter if they're not exercised? And I'm trying to think if there's anything else you brought up. I did ask Senator Peterson this year. I did a FOIA request about his communications with Michael Bills, employees. And the senator reminded me that, in fact, members of the General Assembly cannot be FOIA'd. Now, I disagree with that interpretation of the law, but this is what happens when citizens are trying to get answers around these questions. Stonewalled, sorry, we don't do audits. Sorry, you can't FOIA me. And then it's just sort of, well, all we have is you. And the reason we only have you is because the governor, Northam, ran on banning corporate contributions, limiting contributions to $10,000 apiece. Nothing happened under his administration. It went away as an issue, right? And now here we are in another gubernatorial. Terry McAuliffe, Glenn Youngkin, I don't think either of them have anything about this issue on their websites. They're not campaigning on it. So, you know, I think we're left with you. The General Assembly is supposed to represent us. And, you know, I was hoping any of you could address at some point what it is you think you're doing here. Are you going to be operating as a de facto conference committee on Delegate Simon's personal use ban? You know, that's a possibility. Are you actually looking to do comprehensive reform? Or are you doing what a commissioner from the Wilder Commission several decades ago told me would be the case here, which is, well, Josh, they're setting up a commission, so what do you think is going to happen? That in itself is a method of kicking the can down the road. So I would hope that, you know, that you could sort of tell us what you really think you're doing here, what you believe you can get out of this realistically, and, you know, that would at least reassure the public and help us vote in the General Assembly and the statewide elections this year with this issue in mind for those people who really do care about it. So, thank you.
Thank you. Anyone else? All right. Well, with that, we'll go ahead and close the public hearing portion of the public comment to the extent that needs to be closed. I do think that the question we have next before us is which of these issues do we want to sort of prioritize as far as next steps, and what do we want to tell staff we want to try and accomplish at our next meeting? Do we want to pick a few of these issues to focus in on? Do we want to create some sub-work groups to work on some of them, or do we want to have staff come back to us with some recommendations? So I'm going to throw it open here a little bit. I have some ideas, but I'd rather hear what other commissioners think, if anybody. Delegate Bulova?
Yeah, thank you, Mr. Chair. And I guess getting to Josh's last question, as the patron of the legislation that has caused us all to be here, my intent is for this to be a very meaningful process. I have no interest in kicking the can down the road or dealing with just a single issue. My frustration over the last couple of years is that people will put in good faith efforts for campaign finance reform, and I think there is an appetite, and I think there is a desire to do something, but it's a death by 1,000 cuts. And so you have a piece of legislation that is thrown in, and folks are like, hey, we'd like to do something, but we're not sure if that's the direction we want to go. And so I want us to have a good dialogue. I want us to identify our different options. I want us to be realistic and hopefully build consensus, because I don't want to have something coming out of this body that doesn't have some kind of chance of being able to go ahead and pass. So if that kind of gives you an idea of where I'm coming from, I want to be as aggressive as possible, but I also know that this is a consensus-driven process, and we need to make sure that we are getting as many people brought into this as possible. As far as where to go next, Mr. Chairman, I'll just go ahead and throw this out here for discussion purposes. I think that it would be very useful to have some kind of work group between now and our next meeting to focus on the personal use issue. It sounds like we are potentially close enough where with the right meeting of the mind and with legislative services staff, we can come back to the next meeting and be able to hopefully get some discussion and maybe some blessing with respect to the approach that we're taking, and at least get that issue off the table. So that would be kind of my first recommendation. The second one, I think, really gets down to the issue of a lot of what we've already passed doesn't mean too much if we don't have some kind of auditing or enforcement or better data collection process. And I guess, one of the issues that we talked about, and I didn't realize this was the case, was even in terms of digital ads, that we have laws on the books. It's just a matter we don't have the bandwidth to be able to enforce violations of that. So what I would be very interested in maybe diving into during the next meeting is how have other states organized auditing and enforcement capacity, because that's going to require budget. And it's going to require staffing. And I have my own idea about what that might include. I think it would be, very robust assistance, auditing, very robust assistance if you're found to be deficient, and then you go into enforcement if you can't solve those problems. But I think it would be very useful for us and staff to kind of talk to appropriations, to talk to elections, and figure out what is the gold standard for how this has been organized in other states. And I guess the other one, and this gets down to the, what is realistic in the short time that we have, is, based on what we heard from NCSL, based on what we heard from, from the people who came out and did public testimony today, having our members just provide some feedback, to our staff and say, hey, what do we think is ripe for really addressing, and having that kind of set the agenda for the next 3 meetings in terms of what we can go ahead and tackle. But, some kind of mechanism to put together a matrix of ideas, and then we can figure out, what it is that we want to try to tackle. So, Mr. Chairman, those are kind of my 3 buckets of what I would love to be able to see, guide at least the next meeting or 2.
So just to understand, I'm going to go to you next, Senator Deeds. So you're suggesting that between now and the next meeting, we workshop some personal use, we get a presentation maybe together on the best practices in audit and enforcement, And then we also come up with a process for picking whatever else we do. Is that essentially what you're saying?
Mr. Chair, you've hit that perfectly.
Okay. Senator Deeds.
And I don't really disagree with a whole lot of what Delegate Bulova said. I think we ought to follow up on that and a suggestion that Senator Servell was making. We ought to hear from the Department of Elections at the next meeting about what it would take to provide real auditing within the Department of Elections of campaign finance reports. It doesn't do any good for us to say Virginia requires full disclosure when we don't have the mechanism for figuring out what's disclosed. What kind of fee would it take for us to develop a real disclosure, a real auditing function within the Department of Elections? Senator Servell suggested that there be some modest fee attached to the campaign finance disclosure. I think that makes sense. I think it makes sense for us to figure out how much of a fee we need to impose, and that's something we can probably get accomplished pretty quickly. Maybe.
Thank you, Senator Deeds.
Mr. Chairman.
Ann, are you receiving recognition? You're turning back, or are you just listening? Yes.
Thank you. I feel like I'm just the least informed of all of you here, and I'm amazed and so pleased that you all are wrestling with this. One of my major interests is local elections. You're looking primarily at state elections, and I have a great deal of experience with local elections. And this monitoring is really important, and it's going to address a whole lot of problems that I've seen at local level. So I'm with you on the Board of Elections and looking at the issues that you
Mr. Chairman.
Hey, I think Senator Favola was in the queue, and then we'll go to Senator Servell and then Senator Norman.
Okay, I just had a follow-on on that, but all right.
You have to
Okay.
wait.
Thank you, Mr. Chairman. I guess this is part of the accountability point that Senator Deeds was making, but I would like to understand what we could do better to make public access easier and make it so the average person can get meaningful information regarding our reporting requirements. And maybe the Board of Elections would have something to say, maybe VPAP would have something to say about that. But my sense is we're going to need some infrastructure in here, and we might even need some technology dollars for an upgrade of our systems. So I'd like to put that into a bucket that the committee goes forward with. And I was going to say to the point to one of Delegate Bulova's points on maybe setting up a process for more information gathering from our colleagues. My sense is I would try to move forward as much as we can with the work before us and what the committee can prioritize before I would go out with a survey of any kind, getting more information, with all due respect. Thank you, Mr. Chairman.
Senator Servell.
Thank you, Mr. Chairman. First of all, I think generally in agreement with what you articulated, or you and Delegate Bulova articulated a minute ago in terms of the process. Having been right in the middle of the personal use issue during session, I don't think there's any question there was a consensus in both chambers to try and do something about that. The issue was just trying to figure out the proper mechanism, and there was a whole chicken and egg issue about wanting to see what the State Board of Elections might have said pursuant to your method versus us sort of more dictating it statutorily through ours, and trying to figure that out on phone calls between floors is kind of a hard way to do it with a gun in our head with the deadline coming. But I think if we sat down and talked about it, we could probably figure out something on that. Following on to the local government issue and the audit issue, I think part of setting a fee for auditing, part of what the State Board of Elections is going to ask is what are we being asked to audit, and how many reports are there out there, and how many filing fees are we going to collect. And the reason I mention that is because many of our local government officials do not electronically file their reports. And so the only way you get disclosure of those reports is you have to go down to the clerk's office at the town office or whatever and get a piece of paper and look at it. And I know that the code currently provides that localities can opt into electronic filing of their campaign finance reports. And there's some localities that do that, but most don't. And I think one of the threshold issues for determining the right fee might be whether or not we require mandatory electronic filing of local campaign finance reports, because my guess is that would probably generate a lot more revenue to help with the broader auditing. So I think that's another threshold issue we have to talk about it if we're going to go that direction.
Thank you for that. Senator Norman?
Thank you, Mr. Chairman. There clearly are an abundance of issues that are out there that I think are ripe and appropriate for our consideration. But I hope that we don't get in the area of aspirational rather than being grounded in reality. And I think clearly the priorities that we need to establish, we need to focus on them. There are so many issues out there that I think it's reasonable to anticipate the work of this commission or a subsequent one is going to be multi-yeared. And being grounded in reality, my colleagues over in the House of Delegates are going to be distracted here very shortly, and that is not a criticism, it's just a point of reality that between trying to maintain the personal affairs and responsibilities in your life and running for public office, our ability to laser focus on this, if we have too much of a robust agenda, might very well dilute what we do. So I'm hoping we can really focus on a couple of issues and knock them out. And then if we do have the elasticity to pick up something later on, but let's don't get diluted with our own aspirations here.
Thank you, Senator Norman. I think, that's part of what the planning for the next meeting would be, to figure out how much of this to take on. I don't know that, maybe I'm misspeaking, maybe Delegate Bulova was asking about all the members, but I thought his decision process as far as the next meeting was members of this commission sort of telling us what their priorities were for going forward, so we can keep that focus. To the general membership. Is that so? And then I think Delegate Scott is looking to weigh in, and we also have the folks online, so don't be shy, Delegate Byron, Delegate O'Quinn, if you guys want to weigh in, or Ms. Robinson.
Thank you, Mr. Chair. I guess I want to echo some of Senator Norman's comments as well. And my biggest, being kind of new, I'm going to say new people stuff. I don't want to get distracted with the things that we can do. I want to focus on the donut and not the hole. There are a lot of issues here that sounds like a huge wish list that we have here. And I'm just concerned that right now I don't see, and I guess I serve with 140 folks and 100 on my side. I don't see any rampant corruption going on. And so it's just kind of concerning to me that some of these statements and comments that are being made in an idea for good governance. I'm all for good governance, but I don't see some of these issues. And I think, we need to be very, very careful when we start talking about who can give and when and how. And I just want to focus on those things. I'm very, very strongly supporting that we don't use campaign contributions for personal use. And beyond that, then I want to really, really be very, very focused on what we do beyond that, because I think we're going to get into some areas where you start picking and choosing winners and losers, who can contribute and who cannot. Can Facebook and Amazon, who are publicly traded, and others who are not publicly traded. And I just want to start going, I don't want to start going down that rabbit hole at this commission. If that's something that we want to do in future years, I'd like to be able to get something that we can all get behind for January when we start next session. Thank you.
Thank you. Is anybody, no pressure, but if anybody online wants to weigh in, I don't want you to feel excluded from the conversation just because you're zooming in. We're happy to hear from anybody else. Delegate Byron, Delegate O'Quinn, Ms. Robinson.
Thank you, Mr. Chair. This is Delegate Byron. I'm just absorbing everything that you're saying and listening to all the words of wisdom from the committee. So thank you.
Same. Thank you, Mr. Chair. And same for me. I think based on prior statements that we've identified a low-hanging fruit in terms of using some of funds for personal expenses, such as childcare. So if it's a issue where we could get agreement, then we can move on. I would say let's try to tackle that first.
Thank you. All right, anybody else? Okay, so it sounds like what we want to try and do, if I've just captured what I've heard, is I'm happy to schedule with anybody who wants to be on a small group to talk about wordsmithing personal use between now and our next meeting. We will get we will ask to appear at our next meeting somebody from the State Board of Elections. Is there anybody else that we should be asking to have come present on?
Mr. Chair.
VPAP.
Oh, yeah, I was going to say if it's appropriate, VPAP.
Okay, we'll talk to David Poole and see if they're willing to send some folks and talk about, and maybe somebody from, I don't know who does the IT piece. Maybe that's somebody from SB. We just need to ask for that. But what would it take to sort of take what VPAP does in-house? Is it something we want to take on? And we would hear from VPAP some of what the shortfalls are with the data. So we get to that audit and enforcement piece. And then I think the third thing we want to do is maybe talk to Brooks or the clerk staff about having some sort of Doug, why don't could you elaborate a little bit on this decision matrix process and what it is that you have in mind for getting us all to pick whatever other issues we're going to have bandwidth for?
Yeah, no, thank you, Mr. Chair. And I think it fits very much in line with what Senator Norman was talking about, which is we don't want to have so many different issue areas that we overwhelm ourselves and we aren't able to come to consensus on legislation going into the 2022 session. And I think we also need to be respectful of the fact, that we have Brooks and other DLS staff that are going to have to be putting pen to paper, because it's one thing to talk about concepts, quite another to actually have to come to consensus around specific pieces of legislation. And so the idea is we've heard a lot of really great information, both from NCSL, as well as our public speakers. I imagine, at least based on this conversation, we all kind of have in our heads what that low-hanging fruit or what some of those really targeted areas are likely to be. And so if based on this we can get that information, I think that allows us to put into kind of a matrix form, what are the areas of overlap, that have the most promise for developing that consensus so we can provide some further guidance.
All right, so is everybody comfortable if I move forward with an agenda, working out an agenda that addresses those items between now and our next meeting? I guess the next thing we need to do is probably pick a date for the next meeting. I think we could probably poll. I don't want to try and do that here from the dais, but I think given our timeline, that we probably want to shoot for probably the middle of September for another meeting, because I think we have a deadline of November 1st to report. So if we want to try and get 3 more meetings in, we probably want to target sometime mid-September. Maybe we can have the clerk staff, poll everybody's calendar, give them a few options to choose from.
I would, Mr. Chairman, I would say that no later than the second week in September if you're really going to move things along. And we have to, based on our deadline for the report.
Let's see. So I'm going to pull it out for a second to see. So you're thinking the week of September 6th or the week of September 13th?
6th.
I was thinking the week of September 6th, but then I'm a little
okay.
Anxious. I never let grass grow under my feet, but I think you start with the 6th. If we have to move it to the week of the 13th, we move it to the week of the 13th. But starting with the week of the 6th might get us, something.
So the 6th is Labor Day. So
it won't be the 6th. It'll
the 7th is Rosh Hashanah.
Won't be that.
So, and I know we typically like to do these on Mondays and Tuesdays. Is that the guidance we get from the clerk's office, or does it matter? Okay.
It doesn't matter.
All right. So then the tail end of that week, so maybe the 8th, 9th, and 10th, we could
have options. Give us
some options for those, and then we'll see what works for the majority of members. And then I guess the other question, the other way to maybe, if we're having some trouble finding a date that works for everybody to come to Richmond, we do have the option of having information-only meetings at which we take no votes, where we wouldn't necessarily need to have a quorum here in the building. So if we maybe postpone our votes for the one of the later meetings, that'll give us some more flexibility to meet as often as we need to.
I was just going to mention that.
Any further business to come before the commission?
Mr. Chairman, if Is Delegate Bulova going to be asking for volunteers on the personal use legislation?
I actually was going to be asking for volunteers, so am I hearing a volunteer? So if you want to be part of that group, please give me a contact. You guys all know how to reach me, I think, and we'll get a group together and we'll see what we can figure out. All right? All right, anything else? All right, we are adjourned.